SJC-10873, Commonwealth v. Thomas Evans.
Okay, let's proceed.
May it please the court, Leslie O'Brien for Thomas Evans. This court has said that in a circumstantial case, the prosecution is not required to prove that no one else could have killed the murder victim. But I suggest that surely it's not enough where the proof is that many people could have killed the victim. This is a case where the victim, Ms. Doherty, was an extraordinarily vulnerable individual. She was a pitiable individual, not just because of the terrible death that she suffered, but because of the circumstances of her life, what her life had become before she died. She was a tiny, sick woman running a crack house with no protection in a first-floor apartment in which, when her body was found, the door was unlocked. Now, it's not contested that the defendant was in Ms. Doherty's presence from September 29th, Friday, to Saturday, September 30th, sometime in the afternoon. But there was testimony from the medical examiner that Ms. Doherty may have died, that she died sometime between Saturday and Monday morning. And there was also, as I say, this testimony that when the body was discovered, the door was unlocked. No one knows for how long. This court has stressed the importance of evidence in a circumstantial case that the defendant was with the victim at the time of death. And this is true not only in the cases that I've cited, Commonwealth versus Maza and Commonwealth versus Lau, it's equally stressed in the cases that are cited by the Commonwealth. And I'm talking about Commonwealth versus Rojas and Commonwealth versus Anderson. In those cases, the court speaks of the evidence that the defendant was in the victim's company within an hour or two of the time of death. The court speaks of the fact that the doors were locked from the inside, about the fact that the defendant had access to the particular type of weapon that was used in the murder. In this case, we have none of that here. Now, the Commonwealth's theory in this case was that
Well, we do have the defendant admits that he was there around the time of her death, doesn't he?
he admits that he was there up until the afternoon of Saturday. But we don't know, because of the medical examiner's testimony, that she could have died as late as Monday morning. We don't know when she died.
But isn't there also evidence that the defendant was a major contributor of the DNA found in all 4 of the victim's blue jeans pockets?
There was that testimony, Your Honor, and I want I'd like to actually address that first. I'm arguing, and argued in my brief, that even if the defendant stole money from Ms. Doherty, and I'm not conceding that, but even if she did so, the Commonwealth's evidence falls far short of showing that he murdered her or had any reason to murder her. In regard to that DNA evidence in her pockets, the evidence was, as I've said, that the defendant was in Ms. Doherty's company for an extended period of time. There was even testimony that on Thursday he went to the bank for her, withdrew money for her, so that they both touched this money. There was testimony there was evidence from the defendant's statement and from a young woman's testimony that they were playing cards during this period of time, that they were doing this partying that was referred to. So there was an extended period of time where there was exchanges. The defendant and the victim were touching the same thing many, many times over a period of, say, approximately 24 hours. So it wasn't necessary for the defendant's hands to be in the victim's pocket for that DNA evidence to be there.
But there was other
And-
DNA evidence too, wasn't there? That was that didn't show the defendant as the major contributor. Wasn't it DNA evidence under the victim's fingernails?
Yes,
that was
and this is-
some other male contributor.
Exactly, and this is a critical point, Your Honor, that there was the testimony, that the DNA evidence was that an unknown male's DNA was identified on the fingernails of the victim. It's important.
Can I ask you about this? I mean, there were the two men that were, you point to as possible other people
Yes.
with motives and opportunity and means to have killed the victim.
Yes.
And that their DNA was never obtained. And they testified at trial. Was there any questioning on this point?
There was questioning on that point. Defense counsel definitely raised that. He argued it in his closing that their DNA had never been taken. There was, in addition to those specific enemies that she had, there was testimony about another named individual, a plumber who had threatened her, who had threatened to put her in a dumpster. And I'm also arguing that just the fact that she had this ongoing traffic of drug addicts coming in and out of the house, and this unlocked door, that too is a major hole in the prosecution's case. There's no reason to believe that we knew that after Saturday night there were a lot of phone calls coming in, there were unanswered phone calls. There's no reason to believe that people didn't continue to come to the house, people who were perhaps desperate for drugs coming to the house. So there were many possible perpetrators in this case. Certainly the owner of the DNA profile that was found on the fingernails rather, of the victim was a person who was a primary suspect in the case, although we don't know who that male was. Now, I've stated that I can't concede that the defendant took the victim's money, although that was supposed to be the motive in this case. And there were a couple of reasons for that. One involves the fact that the DNA, there's a perfectly plausible and reasonable explanation for his DNA being in her pockets because of the extensive contact that they had. But also, even if it had been proven that he took her money, if you look at the Commonwealth's theory, what the theory was that he already had taken the money. He had already taken the money when Ms. Doherty woke up, and then at that point, after she woke up, for some unknown reason, he would have become inflamed, impassioned enough to strike her repeatedly 12 to 14 times over the head, fracturing her skull, when he already had the money that the prosecution says was the whole motive for the crime.
Can I get back to those bloody fingernails?
Yes.
Was there any indication on the defendant that he had been scratched?
There was no indication that he had been scratched, or that he had been injured, and it certainly the testimony was clear enough that was not his DNA, absolutely not his DNA on the fingernails.
Blood?
But there was blood on the fingernails. It was somewhat. It wasn't exactly clear whose blood that was. Whether the expert testified that she could not say whether the profile came from blood or from tissue. That was just something. She said that wasn't her area of expertise.
With respect to the DNA that was found in her four pockets, was there evidence that under a transfer theory of DNA, you would have not gotten as much DNA as was found in the four pockets?
No, there was nothing like that, Your Honor. There was the the Commonwealth's expert acknowledged quite a number of times that transfer evidence could produce the primary profile. She explained what transfer evidence was, meaning the type of evidence that comes from the playing cards, exchanging currency, that sort of thing, and said that there were a number of studies that showed that there would not be a primary, that would not be the primary profile, but that one specific study had shown that, yes, it was quite possible that that could be the primary profile due to secondary transfer. And she said that several times. But I wanted to just return to why the prosecution felt so wedded to this theory that they had, that the defendant had to have taken the money before Ms. Doherty woke up. And it obviously, if the jurors believed that there was a struggle, that DNA evidence on the fingernails is a huge problem for the prosecution. If the jurors thought that there might have been a struggle, the fact that another male's DNA is on the victim's fingernails, it would be just about impossible for the jurors to find that the defendant was the killer. There would surely be reasonable doubt that the owner of that DNA profile must have been the killer, unless there was no struggle. So the Commonwealth sought to prove, on pure speculation, I suggest, that there was no struggle here. What they offered in support, trying to prove that there was no struggle, they said, well, things weren't scattered all over the room. Well, that does not mean that a struggle couldn't happen in a small, confined area. That this was a terrible, violent incident, a terrible, violent attack.
Was the evidence that it was exactly the way that one witness had left it?
Yes.
Nothing had changed.
Well,
She
there
left
was...
them asleep and then came back, and it was exactly the same way.
Well, of course, it wasn't exactly the same because Ms. Doherty was now over onto the floor. There was blood on the walls. There was certainly some extreme amount of activity that went on in the area where the homicide took place. So it's really a specious argument to say that, oh, because nothing was knocked over in the room, the victim could not have struggled. Surely she could have struggled in the space that was in which all of the violence took place against her. There's no reason she could not have struggled. It's a specious argument. Well,
consistent with someone being in bed and then waking up and being struck on realizing by the perpetrator, the defendant, that, oh, now she sees me, I've taken the money, and now she's up, and she's going to identify me.
But of course
Hasn't moved from the bed.
Well, yes. I mean, I suppose you could speculate that he would feel in some danger from her, but it's pure, not just speculative, but unlikely that he would feel that he was in any danger from her. And he's not in danger, certainly, that she's going to beat him up. He's not in danger, I'd suggest, or it would be very speculative, unlikely to say that she's about to call the police to say, well, somebody stole money from my drug house. So the Commonwealth's argument that she merely woke up and this enraged the defendant to the point where he struck her 14 times and fractured her skull many times, it just doesn't make sense. It's a theory, it's speculation, it's imaginative, but it's not the type of, it's not what circumstantial evidence, of course, can amount to proof beyond a reasonable doubt, but not when it's made up of this type of imaginative scenarios, speculation, and that's what we had from the Commonwealth here. I wanted to just comment briefly on the matter of, I know that the prosecutor relied mainly on this opportunity, motive, and means argument. But there was also quite a lot of stress on the fact that the defendant had his clothing washed, which he did. And the argument there was by the prosecutor was that, all right, there was no testimony, there was no evidence that there was blood on his clothing, but he might have been afraid, nevertheless, that there was blood on his clothing, and that's why he washed the clothing. In that regard, I would ask the court's attention to the, in the appendix is the defendant's recorded statement. And what the police did during that recorded statement, they did a little tricky thing there. They said, would there be any reason why Paula Doherty's blood would be in the duffel bag that was used to take your laundry to the laundromat? And you can see that Mr. Evans is not shaken one iota. He says there's no reason, I guarantee you, there's no reason that her blood would be on me or anything associated with me. You can see the confidence there. The trick does not work. He is not shaken one iota. He knows that her blood it indicates powerfully that he knows that her blood is not on him because he didn't commit the crime. So in summary, I'd suggest to the court that where you have a case where there's an unlocked door, a victim in a very dangerous situation, the lack of any evidence that the defendant was with her when she died, the lack of any reason that the defendant had to kill Paula Doherty, and the DNA indicating the profile of another individual on her fingernails, that amounts to a case where no reasonable jury could find guilt beyond a reasonable doubt. And I did omit to say, there was one other thing that, in that regard. The prosecution has argued that because Paula Doherty may have put her hands up in this manner to guard herself, she couldn't at some point have struggled. Well, she could have struggled at an early, just because she did this at some point doesn't mean she wasn't struggling at another point. So I wanted to be sure not to omit that. I know I haven't reserved an awful lot of time for the second argument, but I do want to touch on it briefly, unless there are other questions about the first argument. In regard to that second argument, I don't mean to say that the expert there was not qualified to offer an opinion regarding how the blood spatter came to be on the wall, that could come from a swinging of an instrument. Where he crossed the line was when he was talking about things that the jury was perfectly well qualified to figure out on their own, whether pillows might have blocked blood, whether blankets might have blocked blood, or curtains, that type of thing. But the most offensive was his statement, or actually it came from a question from the prosecutor. What does it mean that the absence of evidence, I believe the quote is, absence of evidence is not evidence of absence. And my understanding of that actually is that it's an argument for the existence of God, that we don't have evidence that God exists, but that doesn't mean that God does not exist. So they take this and have the expert testify, the absence of evidence, the fact that I don't have any evidence resulting from a crime isn't necessarily the fact that I wasn't there, doesn't relate to the fact that I wasn't at the scene. Well, that was a huge issue in this case, and it was an issue for the jury.
I take it that the court struck that testimony.
The court struck the testimony and the court did tell the jury to disregard that. But what the judge also told the jury was that, well, that's objectionable, that's just argument. You should disregard that because that was argument. That really wasn't the point. It was an objectionable because it invaded the province of the jury, and that's what the jury should have been told. It's up to you to decide whether absence of evidence in this case is significant and indicates that there's reasonable doubt. If there's nothing further, thank you, Your Honors.
Thank you.
May it please the Court, Fawn Bolero Anderson, Assistant District Attorney from Middlesex on behalf of the Commonwealth. And with me today is Assistant Attorney General John Verner, who is one of the trial prosecutors. In the defendant's reply brief, the argument that, based on the evidence, it is as likely that the defendant committed this crime as it is that a third party killed the victim appears to be premised on the Salemi line of cases. However, that case is never cited by the defense attorney. This case is a far cry from the situation underlying the George Pappas murder. In Salemi, there were two people sitting at a table, and those were the two potential culprits at issue. The Commonwealth didn't proceed on a joint venture theory in that case, and this court ultimately concluded that there wasn't enough evidence to point to one or the other as being the principal shooter. I suggest to you that this crime here, there was no evidence that there was anyone else that was equally as likely as the defendant to commit this crime. And that moves us into the question of whether the question of guilt was left to conjecture or surmise. Traditionally, this court has looked to the evidence to see whether there is anything to support the four cornerstones of a conviction. First, opportunity, motive, means, consciousness of guilt. Those are the four cornerstones. The Commonwealth's brief fleshes out each of those cornerstones, but I suggest that there is evidence to support each of them. And that distinguishes this case from the cases such as Mazza.
Could you address the DNA evidence in particular, please? Including, in particular, the unidentified male who was the contributor to the material under the victim's fingernails, and the failure to have taken DNA from two of the people who had some means and motive and opportunity.
There was evidence before the jury that in this case there was DNA found under the fingernails of the victim that belonged to a mixture of various males.
Defendant. Plainly not the defendant.
And plainly not the defendant. The defendant was excluded as a contributor to that DNA. There was also evidence that and that was actually consistent with the Commonwealth's theory of the case. The Commonwealth's theory was that the victim was attacked while she was lying in her bed and asleep.
So what's the theory of the Commonwealth about how that got under her fingernails?
Oh, there's always dirt and debris underneath your fingernails, and there would be...
But I thought that the expert testified that this was probably either blood or tissue.
She could not distinguish whether it was blood or tissue.
But
this
it wasn't
isn't the situation where her hands weren't bloody.
But it wasn't dirt.
But she didn't know. But dirt would be tissue. The tissues are in dirt, so it's the matter underneath her fingernails would consist of both. This wasn't a situation where this was a very bloody event, and her hands were bloody from her own blood. So this wasn't where there was no blood and her hands were regular and you could see blood underneath the fingernails. That's not what we have here. This wasn't, there was no suggestion that there was a defensive motion causing her to get someone else's blood underneath her fingernails. What the evidence actually indicates is that there was no defensive forward motion, and instead she was attacked in her bed while she was sleeping. And when she realizes what's happening, she brings her hands up to take cover, and that's the only wounds that she suffers with regard to her hands.
How do you know there was no defensive action taken by the victim?
We don't know for sure. There was no defensive action taken, but based on...
Or that's how it got under her fingernails.
It would be impossible to tell because we don't have a confession or a witness to the crime.
Okay.
So I can't say for sure, and I can understand the concern without that. But if you look back at the evidence, we have all four of those cornerstones. We have evidence that support each of them here. There's nothing that's lacking. If you look at the opportunity, and I think that this brings us back to the opportunity to commit the crime, the evidence shows that the murder happened on Saturday evening. And that's...
But the medical examiner says otherwise, that it can't be determined until pinned down that precisely, I thought.
That's one piece of the testimony, that's right, that the medical examiner said the murder happened sometime between Saturday and Monday morning. However, if you look at the other evidence in the case, I would suggest that it demonstrates that the murder in fact happened on Saturday, given Jean McCarthy's testimony that she helped the victim clean up her room before she departed that late afternoon. And when she came back on Monday evening, 2.5 days later, it was almost in the same identical condition as when she had left it.
So what does that mean?
That means that the victim who she left to go to sleep was killed at some point when she was sleeping. She never got up and lived in her room again. There was no movement of anything. So that's why it indicates the victim was attacked at some point after she fell asleep following her friend's departure.
You mean there was like no glass was taken out, drinking glass or coffee cup was?
No more cigarettes were in the ashtray, and no more drug activity. The chairs weren't moved. That type of activity. And the evidence showed that the main living, all the living actually, went on in this one particular room. The eating, the conversing, the visits, the sleeping, everything was confined to this one room in the apartment.
And when Jean left on Saturday afternoon, the defendant was there, right?
That's correct. He
was
was the last known
sleeping or
person to have been seen with the victim alone. When Jean left, he was asleep in the chair, and the victim had intentions of going to sleep because they had been on a cocaine binge for days up until that point.
And then her phone went off.
And then the next action is that the victim's phone rang at around 6 p.m. on Saturday evening, and it was answered by a male. The male indicated that the victim was unavailable because she was sleeping, and that was the end of the conversation. The next thing that happens is the victim's cell phone is either shut off or the battery goes dead at 8 p.m. that evening and is never turned back on, and nor is it ever found by police. And then,
So how do we know it was shut off?
because the phone records never logged another phone call after 8 p.m. And there was testimony from the phone company that happens if the phone is turned off or the battery dies. They don't record the missed phone calls. And we know from the testimony that there were many people trying to get in touch with the victim throughout the next couple days.
Yeah, and there was no landline or anything?
No, there was no evidence that there was a landline. All the phone conversations and calls were done on this particular cell phone. In fact, there was testimony that the victim received, I believe, 180 phone calls within the 3 days preceding her death, which the Commonwealth suggests happens on Saturday evening. So this case is already on better footing than cases such as Mazza, where there is one of the evidence of the fundamental keystones missing. Such in Mazza, there was no evidence that the defendant had the means to commit the crime, or even the opportunity, because nobody saw the two of them together, the victim and the defendant. But in this particular case, we have evidence that the defendant was the last known person with the victim. So this puts us more closer to the cases such as Anderson and Rojas. The Commonwealth submits that Rojas is probably the closest case to this with regard to the sufficiency of the evidence. In that case, the court looked heavily to both the fact that the defendant was alone with the victim shortly before the victim was found to have been murdered, and there was evidence of consciousness of guilt. In this case, it can't be overlooked that there was significant evidence that the defendant, based on the defendant's actions and statements following the victim's murder, that he was conscious of his guilt. In this particular case, we have evidence that he went out and spent money, a cash spending spree throughout Saturday night. However, he had no cash with him. He ran out of cash on Saturday afternoon while he was with the victim. There's evidence that he tried to barter one of his clocks for drugs from the victim. And then that night, there's testimony that he is in possession of hundreds of dollars. And we know that the victim had a significant amount of cash in her pockets because of the various drug deals she had conducted in the days preceding, which the defendant had observed. Furthermore, when asked by his friend that evening what happened, the defendant suffered a cut on his hand, and he indicated that he had been working that day cleaning gutters. We know that that's false based on the fact that he himself admits that he was with the victim that morning, all morning doing drugs. And that would also explain him having cash to his friend. However, he never mentions this to police. When he's interviewed by police about the victim's murder, and he knows that he's being questioned about that, he distanced himself as far as he can from the fact that he was in possession of a significant amount of cash. The defendant's brief, for the first time, raises the theory that the defendant may have robbed the victim, but he didn't kill her. The evidence at trial belies that idea. There was no evidence of a forced entry or of a scuffle. So like I've maintained throughout the argument, it appears that the victim was killed while she was sleeping in her bed. It's compelling that her bedroom was in the same condition. The contents of her room were almost in the identical location as where they were left on Saturday evening. Her phone was turned off, and and also her defensive wounds are telling of how the murder occurred. These are all significant pieces in the puzzle to determining his opportunity as well as his motive. On appeal, the defendant in Rojas raised the same supposition, that perhaps somebody came into the apartment and killed the victim after he left. In the line of cases concerning the sufficiency of the evidence in first-degree homicide convictions, the courts routinely look at the consciousness of guilt in weighing whether or not the evidence concerning his identity, the killer's identity, is sufficient to to put the case forward to the jury. I submit to you that there was enough for this case to go forward to the jury, and that it's sufficient in light to looking at the evidence in the light most favorable to the Commonwealth, that the defendant was, in fact, the killer, and the jury was correct in rejecting the defendant's theory at trial that it could have been one of these, somebody else who committed this crime, where, in fact, they did hear from those third-party culprits. There was testimony in the Commonwealth's case in chief from both third-party culprits as to their whereabouts and their relationship with the victim. If there are no further questions on the first issue, I'll move to the second issue raised in the defendant's brief. With regard to the contested expert opinion testimony, that testimony was properly admitted by the trial judge. First of all, it was within the purview of Detective Lieutenant Martin's field of expertise. There was plentiful evidence that he was an expert with regard to blood stain analysis, and the testimony that he gave was explanatory in nature. Although it had to do with the absence of blood, it's just as, it aids the jury in the same way that an explanation about how the blood could have gotten on a person, it aids the jury in the same way as that evidence, the blood stain pattern evidence that this court has found to aid juries in the past. The expert's opinion was inconclusive with regard to the question of the defendant's guilt, so that's the third reason why it was properly admitted. The import of the testimony was that the defendant could not be excluded as a suspect, even if the jury were to find that there was no blood on the defendant or on the perpetrator. The Commonwealth did not use the phrase, the absence of evidence is evidence of absence. The absence of evidence is not evidence.
It's not evidence of absence.
Is not evidence of absence. The Commonwealth did not use that phrase in closing at all. And it was taken away from the jury's consideration by the judge, who instructed the jury not to consider it, and that it was repetitive with regard to evidence that was properly admitted before them. Therefore, there is no prejudicial error or a substantial likelihood of a miscarriage of justice based on its admission. If there are no questions with that, I'll move on to the 33E review.
Let's go back a little bit. You said opportunity, motive, means, and consciousness of guilt. Well, in light of this, the victim's lifestyle and what she was running, lots of people had opportunity. Anyone could walk into the place. Wasn't the door open, unlocked?
That's right. Anybody could walk in.
And she had lots of customers, probably not all of them of upstanding nature. So just because this person was the last person that someone saw there doesn't discount that. Lots of people might have motives. The means apparently must have been a tool that was on site. There's nothing special. It's not a particular type of gun or knife or anything. I mean, isn't that true?
It is true that other people could have had a motive, but it's not the Commonwealth's burden to disprove that other people could have committed the murder. It is, excuse me, I'm feeling very lightheaded.
Why don't you sit down?
Yeah, some more.
We'll get you some water.
Thank you.
We better stop the clock here for a few minutes.
Take a recess. Take a break.
Why don't we take a little recess?
Would you like us to take a break and then resume? You've got about 3 minutes, a little more than 3. All right, we'll take a recess. Okay, we're back on the record. We don't have the ability to read back the question. Justice Cordy, do you remember what your question was?
Question's been asked and answered.
Okay,
My apologies to the court, and I thank you for your indulgence.
sure.
I believe Justice Cordy's question went to the quantity of the evidence here that was sufficient, that someone else didn't do it, and in fact, the defendant was the person who committed this crime. If you look at all the pieces of the evidence, it all fits together and as a puzzle would fit. You can't just look at one particular thing in the case to say, you know, there was evidence of someone's DNA underneath her nails, to say, oh, of course it had to have been that person who did it, where in fact the case points to all the signs in the case point to the defendant as being the culprit. And the reason why would be based mostly due to the fact that we know that we don't know, but the evidence strongly suggests that the murder occurred on Saturday evening, and the defendant was the last known person seen with the victim shortly before the murder. In addition to the fact that he ran out of money and was seen spending
Quite a bit of money, and that was
quite a bit of
Saturday,
money.
and that was
Saturday
Saturday
and
evening.
that was Saturday evening throughout the night, and he wanted to continue his cocaine binge. And then that you have to put that in light of his activities that evening. He goes and tells an implausible story to his friend about how he cut his hand and where he got the cash. He has his clothes washed by a woman he's been hanging out with for 15 years, and never in the past has he asked her to wash his clothes.
But there was also evidence as to that somebody had heard that she offered to wash his clothes the night before, and that he'd been wearing them for a couple days, so they were kind of grouty.
The Commonwealth suggests that this would not be the first time that he wore clothes for multiple days with these same people, and never in the past has anybody offered, or has he had his clothes washed by anyone. It's just too coincidental that on this particular occasion, he's getting his clothes washed. In addition to the fact that he lies to them about where he got his hand cut and where he got the cash. That putting all of this together in the light most favorable to the Commonwealth, the court can conclude that the jury was warranted in finding that the defendant was in fact the person who killed Paula Doherty on Saturday evening, and the jury was correct to reject that anybody else committed this crime. If there are no further questions, I'll rest on my brief. Again, thank you.
Thank you, counsel.